The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. So I'm going to begin by calling the case officially. It's case number 2022-0994, the Department of Children and Families versus Father and Another. Before we begin, I'd like to introduce myself and the panel. My name is Ariane Vuono. I'm joined today by Justice Sabita Singh and Justice John Englander. We will be hearing your case this morning. We are on Zoom, but of course you know that this is live streamed and open to the public, and this case is impounded, so please be careful and not use any of the parties' real names. I understand that the FLEs are dividing their time, 6 minutes, 6 minutes, and 3 minutes, and that those amounts, or those time periods rather, will appear on the clock in the corner of your screen. With all that aside, we're going to start by hearing first from Attorney Anderson, who represents the father in this case, and you have 15 minutes to make your argument to us.
Good morning. May it please the court. My name is Scott Anderson. I represent the father in this case. I apologize in advance for looking here. I'm looking you in the eye, but my camera's there. I'm doing my best. In any event,
no problem. We understand how Zoom operates. No worries.
Right. Thank you. So a judge can parse a case record into 1,000 findings, and that doesn't mean anything. The main issue at hand is the evaluation of the parent's fitness, which involves 12 factors. You will find the way this judge treated those 12 factors on page 73 through 76 on the pagination of the findings, or else 121 to 124 on the pagination of my brief. I'm not sure which one is more convenient for you. Of those 12 factors, 6 are found relevant. Of those 6 factors, 3 involve domestic violence. Factor 2 exclusively is about domestic violence, and 3 and 8 are involved with refusing to get treatment for something he doesn't think he has, nor is there evidence that he does have. So for anyone to argue domestic violence is not a central part of this case, I don't understand how you could say that, because that's 50% of the factors, not 5% of the findings of facts, which really don't have much to do with it. And also, please note on page 72, I'm hearing someone trying to talk. Okay, please note on page 72 or 120, depending on your pagination, that Custody of Vaughn is the only block quote in the whole conclusion. It's 20 pages of narrative. The judge not only block quotes Custody of Vaughn, but introduces that block quote with evidence of domestic violence is highly relevant to the parental fitness determination. And that's the only thing he says in this conclusion that is highly relevant. So this is a central part of this case, which is my introduction to this error of law and how this could change the outcome of this case if brought back to the trial court. So
I guess I would start by asking, there was evidence of domestic violence, wasn't there?
That's what I was hoping to get to. There are exactly 2 discrete items, and this is a very unusual case, because when you look at Carla, abuse is supposed to be a pattern, unless there's something very traumatic which you can point at. Typically it's sexual abuse, but there's one horrific episode you can point at and say that's impermissible. But generally speaking, abuse is measured in a pattern. This yelling here, yelling there, spanking here, spanking there becomes abuse. In this case, we have a phone call and we have an episode of spilled food. Those are the only 2 pieces of evidence behind this.
You call it spilled food. I think that the record calls it him deliberately acting or pushing into her face, right?
Well, the judge finds that. I'm sorry.
Yeah, the judge finds that. Is that finding clear error?
I'm arguing it is. That's part of my argument about domestic violence. I'm not arguing against the sufficiency of evidence overall, because I'm hoping just to take this error of law and go further with it. But as part of this error of law, yes, he is looking at this evidence and misconstruing it. And let me just
so help me with what's the error of law?
The error of law is that there is an expansive understanding of what entails domestic abuse. There are guidelines for that expansive view. Among them are custody of Vaughan and 110 CMR number 2, which is the definitions that DCF applies to these cases. Both of them talk, as described in my brief, both of those talk about expansive understandings of abuse, not just hurting someone physically, but hurting someone emotionally, just creating a hostile environment, bad for the child, just through daily grind of bad behavior. All of those things are part of this discussion of abuse. But what we have here are two specific items: a phone call and whatever happened through the excited that was allowed in through the excited utterance. But I actually do have a witness in the record of what actually happened, which I would like to talk about. I keep hearing someone trying to talk. Okay. Did I answer your question, Judge? Okay. So I'd like to call your attention to page 168 of the record, in which we have a witness to what happened between mother and father. It's the person who's calling emergency services. I'm seeing this happen, call the police. All this witness says is that they see a man walking away and they see a woman chasing after him down the street, screaming that she took his money and he smashed her in the face. And then she tells the social worker, as we see from the transcript, that she was bleeding all over and other things. And then when the professionals who are there to assess injuries arrive, they discover no injury, none. So everything that was said over that excited utterance phone call was incorrect. And I understand there's a presumption that there's a veracity to what's said off the cuff. However,
okay, I'm going to interrupt you just for a second and ask you a question that's slightly different, because as I understand from your argument, you are putting a lot of emphasis on the fact that you think, or that you maintain that the evidence of the domestic violence as not insufficient, but there's not a lot of it, and that you think that the judge has overemphasized this. But there are other factors here to consider that your client presented that that also was part of the judge's conclusion. One is that he had periods of incarceration. Second, that he did not have stable employment. He didn't have stable housing. In fact, he indicated that he wasn't going to get stable housing until such time as he needed to. How are we supposed to deal with those factors?
Right. Again, I'm not arguing sufficiency of evidence with regard to domestic violence or anything else. I am arguing an error of law, which I'm hoping can be revisited at the trial level. And what you say is true. I can't hide a bad record. This is a bad record. However, for example, there's the parallel criminal case, right? That's, concurrent to what's happening here, and that's sort of bleeding into it.
Whoa, it's not bleeding into it. I mean, I think if you said bleeding into it, I mean, there's no indication that this father...
I said bleeding. I'm sorry. I apologize. I didn't say pleading, Your Honor. I said bleeding. I said it was just...
Yeah, that's what I thought you said. Yeah, it's not bleeding into it. If I'm the judge, shouldn't I be considering the fact that there's a decent chance that this person is going to be incarcerated for the next 4 to 5 years? How can he be a fit parent if he's going to be incarcerated and unavailable to the child?
That's why I'm not arguing that issue of sufficiency of evidence. That's why I'm arguing.
Right, but let's assume for the moment that there is an error of law, that we still have to evaluate, don't we, whether that is so prejudicial that we need to upset the judgment of the court. And here we, as Justice Vuono started to describe, there are a number of other pretty darn important factors that are considered in any case of fitness that are applicable. And I don't hear you denying that or trying to challenge that.
Well, yes, there is an iceberg in the way, this being the evidence of the criminal case, for example. However, I can't talk about events since the deadline of the determination, and so I'm not. However, if I were to convince you of this error of law, and if my client were able to update the record, there could be a different result. And I'm just trying my best, given this record, to move the ball forward for my client. So I understand, yes, there is evidence, but there's also more evidence which could be brought if we're able to bring it. And I believe that this error of law, if it were so found, would enable us to go back to the trial court.
And
So
just
that's
so
my,
I'm clear, the error of law that you're putting forward is the judge's understanding that this constituted domestic violence. That was the error of law, that whatever behavior was pointed out does not constitute domestic violence within how we understand
Yes.
the circumstances.
yes, the judge is entitled to deference, but there has to be a nadir to that analysis. And there are in other cases, for example, look at Frank, custody of Frank, how you need to look at the particulars of the crime in relation to parental fitness. You can't just say, well, he's got 6 charges, this guy's a criminal. You have to look at if they're dismissed or if it's not guilty, you can take those police records and see if that activity relates to parental unfitness. But you can't just say, oh, he's got a long rap sheet, forget about it.
Well,
So
if the judge here was incorrect on characterizing this as domestic violence, how do we analyze that? Do we say, all right, take away all the findings related to domestic violence? Is there sufficient evidence of other sort of factors? Is that how we analyze it? That we move on to the remaining factors and determine if that's sufficient?
well, what I'm hoping is that after this error of law is returned to be addressed at the trial level, there's weaknesses in most of the other factors. I can go into them, whether it's the way DCF produces a schedule of supposed visits, which were impossible because there's only 170 weeks between March of 2017 and November of 2020, and they're claiming they scheduled 141 when he's incarcerated for 9 months, and they took his visits away for a couple of months. And it's just, that goes to my client's, concurrent brief that he filed. I helped him file under the protocols of Moffitt and Valerie. He says he had insufficient assistance of counsel. I was unable to construct that argument on his behalf, given this record, but the record is awful. I mean, it's kind of, the chicken or egg thing. It's a bad record because of not insufficient counsel according to Safarian. I couldn't make that argument. That's a very high bar, as you know, but I could say this is a poor record with, looking at how many visits he should have gotten. 42 visits is at least once a month over that time period, which is plenty to have a relationship with a child. It's not on the record. I can't talk about it. My client does, and so I'm talking on his behalf. But I'm just assuring this panel that if this were to, there is a point to this appeal, that if we were to get a second hearing at the trial level, there could be a different result. And I think that's the nature of your question, Judge. And I also, just before I run out of time, I wanted to say, Judge Singh, that you were on a panel, Adoption of Jacob, which is actually one of the best cases that describe what I want to say finally, which is that currently there's a public interest thing here where there's 2 tiers of parents. There's parents like Schechter versus Schechter, where you have, the typical, they have resources to that marriage makes sense and divorce is a big deal and so forth. And you get you get phone calls saying, I'm going to chop you up with an axe. And that's part of that case. Whereas here, there's a phone call saying, you took my kid's birthday money and bought hair extensions, and this is an angry phone call, and that's abuse. And that's 2 different versions of abuse. And taking Adoption of Jacob, that panel, your panel, talked about how there should be a different standards, and there are different standards for parents in the one tier, the high tier, where they have their own lawyers doing their thing, and then there's this other tier subject to removal where they don't have that, and they're treated like children. And what happens is they make an angry phone call because someone steals their kid's birthday money, and then they're told they have to go through 12. My client's 56 years old. He used to be a professional boxer. He knows violence. He's been around the block. He doesn't need someone half his age telling him he needs a battering group. This record is unique in that there's not one episode of him yelling. Not one. There's not one episode of him doing anything violent. There's the grandmother, there's a social worker, there's the police, there's all kinds of people aggravating him every day, and not once does he lose his temper on the record. And yet we're supposed to believe, you know, he should be going to a battering group. And
There's
that's
also
really
a finding, though. Mr. Testimony revealed that he has little understanding, has remained wholly ignorant. The child's needs, diagnosis, and treatment.
that's true. And what he says, and it's in his brief, is that he was frozen out by the bias of DCF as well as the grandmother. They didn't want to see him. He wasn't allowed to see his child. He did his best to organize the visits, but there was always a reason for him not to see his son, and that was not on him.
How do we square that with the fact that you just told us that he saw the child 42 times? I understand your argument, counsel.
Okay. Thank you very much, Your Honor. I see my time is up.
Your time is up and you've answered all our questions. We appreciate it. Thank you. Okay, we're
Thank
now
you.
going to return to the other side, and we're going to start with Attorney Salcedo for 6 minutes.
May it please the court, Richard Salcedo for the Appellee Department of Children and Children and Families. The department is asking this court to affirm the trial court's decision finding father unfit and terminating his parental rights. The court's more than 300 findings in this case, when taken together, clearly and convincingly support the trial court's conclusions. In determining father's unfitness, the trial court properly considered a number of factors, which included the issue of domestic violence. As your honors have indicated, the evidence does support, at least in one incident, where mother alleged that father assaulted her. The social worker testified also that there was an encounter in the court between mother and father, where father was hostile and was engaged in a conversation with her in the court. And that was just prior to the incident where mother called the social worker crying hysterically, indicating that father had assaulted her. As Justice Englander mentioned as well, there's the finding at 280 where father was asked about domestic violence and he denied it, but then also admitted that he had shoving matches with mother. And the court noted that father is an imposing figure who had a professional boxing career. So I don't think it's unreasonable for the court to have considered that as a factor. And also it was reasonable to ask father to address that particular issue with services. But
what if we disagree though? If we think
focus
really this
also-
does not constitute, if we come to the conclusion that really everything laid out in the record does not really constitute domestic violence, what's left of the analysis? Does it go back on that basis, or do we look at the other factors?
I think we look at the other factors, Your Honor, and what the record indicates is that father has failed to stabilize his life. He's had more than 6 years to do so. He continued to engage in criminal activity throughout the pendency of the case, which resulted in periods of incarceration, which rendered him unavailable to have contact with the child or to provide any kind of care for the child. The court found that father's continuing criminal activity resulted in 10 distinct periods of incarceration in Massachusetts. The court also focused on father's lack of stable housing. Father's been struggling with chronic homelessness throughout the case. He was homeless before the child was born and continued to be homeless up until the conclusion of trial, and had he told, when he was not incarcerated, he mentioned to department social workers that he basically would stay wherever he could with friends or at shelters. The court also focused on his failure to follow through on other services. He had not engaged in individual therapy. There were periods of time, first 2 years of the case, where he only had sporadic contact with the department. He failed to sign releases at times so the department could confirm his participation in services. And the court also noted father's failure to inform himself about his child's needs, his child's history. He was provided with information. There was testimony that he was given information regarding the child's medical and emotional needs, including an individualized education plan. Father, in his testimony, did not know what an IEP was. He didn't ask to see the IEP. He was invited to meetings, including early intervention, but failed to attend. He was given contact information for the child's teachers. He was to the child's therapist and doctor, but he failed to contact any of them. He was also told that he could attend events at the child's school, but he failed to do so. So in sum, father has failed to demonstrate an understanding of his child's needs, and also failed to demonstrate that he can provide the child the kind of stability and structure and predictability that he requires. So unless the court has any other questions, I would ask that you affirm the trial court's decision.
I see no questions from the panel, so I thank you for your argument, and we'll hear for the next 6 minutes from Attorney Matos.
You may please the court, Attorney Rachel Matos on behalf of the appellee child. First, I would just like to state that the child was 6 years old when the trial ended. He had lived with mother for the first 13 months of his life at maternal grandmother's home, where he currently remains, and that other than a brief 8-month period when he lived with mother at a residential treatment center, he had resided primarily with the maternal grandmother. With respect to the domestic violence, father spent a significant portion of his brief parsing out that definition. However, when the judge had just merely considered domestic violence, as you've heard from the department today, as one of the many factors supporting father's unfitness. And despite father's argument that was the focus, it was not a significant or primary basis for the judge's overall decision. The child was not removed because of domestic violence, but he was removed due to mother's substance abuse during her pregnancy. The judge's conclusions, he references father's criminal activity, incarcerations, absence from the child's life, missed visits, and a lack of knowledge of the child's needs. Additionally, lack of housing and steady employment, before the judge even mentions domestic violence as a factor. Domestic violence was the last factor that the judge references in consideration of father's fitness. The judge made 397 findings, and only 14 findings referenced domestic violence. Domestic violence not a significant consideration in the judge's decision. And even if this court agrees with father about the degree of the domestic violence in his relationship with mother, the decision of the lower court must stand because there were so many additional factors that were prominent in the judge's decision. Father was largely absent most of the child's life. He spent the first 6+ years passively observing in the child's life. Following the child's birth, father was arrested and detained, and that left him unavailable to provide care for the child. In fact, his criminal activity resulted in his being repeatedly incarcerated for a few days to a few months from the very beginning of the case up until just before trial, and he was only released pending a stay of his sentence on a motion for a new trial. As you've heard earlier today, during his incarceration, the father only had 3 visits with the child and which led him to be largely unavailable to provide necessary care for the child from his birth through the end of the case, through the trial. His first visit with the child was while he was incarcerated. He had another couple of visits after that while he was incarcerated until he was released. He missed numerous visits. As I say, heard that today already. He was noted to be inattentive during the visits, and the judge was correct to consider his failure to visit as evidence of unfitness. He missed more than 100 scheduled visits during the pendency of the case. He attended less than half as many visits as he had missed.
What do you say to your opponent's comment that you couldn't possibly have missed 100 visits, just given the number of visits that were scheduled or could have been scheduled in the time period involved?
That wasn't raised below. That's what I would suggest the court and the judge.
But what about the math?
I think I'd have to suggest that father had ample opportunity to raise that, and I think that the record supports.
If we're confronted with a record that actually can't be correct, that's an issue that we need to address, isn't it?
Yes, but I would suggest then that even when father was not incarcerated and he may or may not have missed exactly 100 visits, he still wasn't involved in the child's life. So that was one factor that the court considered. But the court also considered that he had little understanding of the child, that he didn't sign releases when he was asked to do that. He was ignorant of the child's needs, his diagnosis, his treatment. He took a backseat role to finding out specifically what the child's needs and what they were. As you heard earlier, he was offered to be involved in that capacity, and he did not take an active role. He was invited to attend child's EI sessions, and he declined those invitations. He also did not, he was invited to reach out to the child's teachers, therapists, doctors, etc. He had all of the contact information for all of the providers, and he didn't reach out. I think father's testimony at trial was also telling, and it revealed that he had no real understanding of any of the techniques used to focus on or calm or redirect the child, or the structure of the child's life. Also, I think
actually, your time is up, as you can see. I think you can see in the corner, but I don't want to. You can finish your point, of course, and I want to also make sure that Justice England or Singh does not have any additional questions for you.
Thank you. I'll rest on my brief.
Okay, I don't see any more questions. All right, so we're going to conclude the argument today with just 3 minutes that are allotted to Attorney Kornblue. Is that correct?
Yes, it is. Thank you, Your Honor. My name is Deborah Kornblue, and I represent the mother in this case. And I want to thank the court for allowing the mother a limited status in this appeal. As the court is aware, The trial court accepted mother's settlement agreement by way of an open adoption agreement. The lower court did. And then in March, this court gave mother the opportunity to discuss the only viable plan that the parties presented to the lower court. This case is 8 years old, DCF having filed it in 2015. As child's counsel stated, but for about 8 months of the child's life, the child has only lived with the maternal grandmother and has never lived with the father. The evidence clearly and convincingly showed the grandmother had the skills and capacity to respond to the child's numerous needs, which she had done during the entire time the child resided with her. As the court is aware, this court's review for a best interest determination under adoption of Hugo, 428 Mass 219, and Jacob, adoption of Jacob, 99 Mass App Court 258. This court gives substantial deference to a trial court's determination of best interest. The court should know that the father does not challenge any of the 390-something findings of fact that the trial court made. When it comes down to it, he only takes issue with the weight that the court gave to the father's criminal record and the manner in which the lower court decided there was domestic violence, which, by the way, adoption of Jacob clearly states that physical abuse and violent behavior is completely unnecessary to a finding in a termination case of domestic violence, and that controlling, threatening, and unpredictable behavior is sufficient.
Do you think it's domestic violence if father gives money to the mother, finds out that the mother has taken the money and used it for a purpose completely inconsistent with the reason the father gave her money, and he gets angry at her over the phone?
Okay, well, first of all, that's incorrect. The father left out a very important fact in his brief, and that is at the transcript, page 34, actually, the testimony is that the mother did use a portion of the money that he gave her access to from his storage unit where he had vast amounts of money. He gave her access to that. She used some of it for herself and some of it for the child's birthday. However, what's omitted from the brief is that he also asked her to get the money to bail him out of jail at the time. So that's omitted. And yes, I do think, Justice Englander, that when someone controls another person by way of their purse strings, especially a person who has a substance abuse problem, as my client had, it is a form of domestic violence and abuse. So that was clear, and Jacob supports that. One other point I'd like to make quickly regarding visits. This father was offered a pass, a free pass by DCF to travel outside of Boston to see his son. And he said, why should I? It had nothing to do with the child's needs. And in response, DCF got 2 workers to accompany the child on very long transportation rides to the child's detriment down to the Boston area to appease the father and allow him to have visits. And that I would ask that the court affirm the TPR decision, the termination of parental rights decision against the father, and affirm the adoption plan forthwith. Thank you, Your Honors.
Okay, I want to thank everybody who argued today very much. We know these cases are always difficult, and I can assure you that the panel will give its utmost attention to everything you've said to us today and everything in your briefs as well. So thank you very much, and we'll get back to you as soon as we can.
you.
Court will now, Zoom will now be in recess, so to speak, and we will adjourn in the actual courtroom. Thank you.